A hearing has begun to help determine whether a Georgia railroad can legally condemn property to build a rail line. Atlanta. A trial began Monday in a pivotal turf battle that involves one of the poorest parts of rural Georgia but could have ramifications for property law across the state and nation. At issue is determining whether railroad can legally condemn property to build a 4.5-mile-long rail line that would serve rock quarry and possibly other industries. A hearing officer will take testimony for up to 3 days before making a recommendation to 5 elected members of the Georgia Public Service Commission, who will make final decision. The line will be built by the Sandersville Railroad, which is owned by an influential Georgia family. It will connect to the CSX Railroad in Sparta, allowing products to be shipped widely. People in the rural neighborhood don't want train line running through or near their property, in part because they think it would allow for the expansion of a quarry owned by Heidelberg Materials, publicly traded German firm. Some residents already dislike the quarry because it creates noise, dust and truck traffic. Supporters say railroad, if built, move quarry operations farther from homes. Trains would reduce trucks on the roads, and railroad build levees to protect residents. But property owners say losing a 200-foot wide strip of property to the railroad would devastate lands they value for peace and quiet, hunting, fishing and family heritage. Sandersville Railroad does not care about the destruction my family's property or our way of life. One the property owners, Donald Garret Sr., said in written testimony in August they only care about their own plans for my property. Which is my property. It will not serve the public. It will only help them expand their business and the quarry's business. Opponents have very powerful allies, including Institute for Justice, which hopes use the case to strip public authority of government's ability legally take private land by paying fair compensation. The libertarian-leaning legal group was on losing side. A landmark 2005 case that allowed the city of New London, Connecticut, to seize land from one private owner and transfer it to another in name economic development. The decision sparked widespread backlash, including more than 20 states passing laws that would restrict public rights. Railroads have long had exclusive authority, but Georgia law says seizing such land must be for public use. Opponents targeted the project, saying it would only benefit the quarry. This is not an obligation on private property owners to truly serve the public interest and the public as a whole. Daniel Kochan, a law professor at George Mason University in Virginia, testified on behalf of the opponents. Sandersville Railroad says there are other users, including a company co-located with the quarry that blends gravel and asphalt for paving. Many companies have said they want access to CS